I guess we can start, and the others will join us in a few.
Okay, perfect. Well, good morning or good afternoon, everyone. Welcome to this webinar dedicated to Indian cosmetic industry and how can European SMEs protect their brand and innovation while going to this market. In fact, with a large young population and a growing middle class, India offers a huge market for European SMEs. To explore, it's a market to explore. The Indian cosmetic market is worth 5.49 billion euros and is expected to be growing at 18-25% annually. So with organized retail landscape, supply chain availability, skilled manpower, large and growing domestic distribution channels, and presence of raw material, India is and will continue to be a very important actor in the cosmetic industry. Given the market size, the demographics, and also the cosmetic and luxury products landscape, intellectual property plays a vital role in protecting brands and products associated with it. So this webinar is organized by Global Cosmetics Cluster Europe and the Indian IP SME Helpdesk. We will explain you a bit more about that in a few words. It is mainly designed for European SMEs that would like to, or that are interested, or that are already doing business with India. And the overall aim is to build capacity and to ensure that SMEs can exploit business opportunities in the Indian market. So I will let Girish explain you more about IP, of course, during this webinar, but let us present GCC.EU, so Global Cosmetics Cluster Europe, and India IP SME Helpdesk before. So here's the agenda in a few words. So I'm Ségolène Leloutre from Cosmetic Valley, France, in charge of the international partnerships, but also coordinator of the Global Cosmetic Cluster Europe. I will give you a few words, then Stefano will present the Indian IP SME Helpdesk, and Girish will follow up with the main topic of the day. Of course, we'll have a Q&A session in order to discuss and answer your question. And let's have a great webinar all together. Don't hesitate to ask your question online on the chat part. So in a few words, what is Global Cosmetics Cluster Europe? It's a European project co-funded by the COSME program of the European Union, and it's held by 6 European clusters: Cosmetic Valley, ABB, Beauty Cluster, ICMI, Polonia Cosmesi, and Transylvania Lifestyle Cluster. So from France, Portugal, Spain, Italy, Turkey, Romania, I think I didn't forget, and Spain. So the idea is to boost SMEs internationalization, business opportunity in different countries. We are targeting 5 countries, but our objective is to boost SMEs competitiveness, to represent the European cosmetic expertise, and to foster European cluster collaboration. What about the acceleration program dedicated to SMEs? So it's been more than a year that we are working on that topic and proposing SMEs, European SMEs, different actions on market intelligence, on capacity building actions, international trade and partnership, and on funding opportunities. So it's Market Watch that are available for SMEs on Korea, India, Mexico, USA, and Emirates. It's also training that have been given to companies, and today is part of the training and capacity building action. Specific advice, you can ask us for any question about those markets, and we will be able to give you the best answer on that. We are working also on a business place in order to foster collaboration between companies for business and innovation also. Well, I'm just giving you some few information, and it's important to highlight that in the first semester of 2022, we will organize also 2 missions, B2B missions for SMEs to South Korea in May, by the end of May, and to USA mid-July. We'll send you, of course, more information about all that, but it's just to save the date in your mind. Well, this was just to have a little overview about the acceleration program. Don't hesitate to ask questions, to go on the website dedicated to that, to go on social networks. We open to discuss. It's 5 markets we are targeting all together, and it's made for you as SMEs in the cosmetic industry. So I'll let Stefano talking about the IP Helpdesk in India, and then Girish will follow up. Thank you.
Thank you very much, Ségolène. I'm going to try to share my screen. Let's see if this works fine. Can you confirm?
Yes.
Great. So good morning, everyone. Welcome to this webinar on cosmetics and intellectual property. My name is Stefano Guardati, and I'm a project officer at Eurochambre. Eurochambre is one of the partners that are working on the India IP SME Helpdesk. And today I'm just going to give you like a very few words about what we do in the helpdesk. Exactly, you may ask yourself, what is the helpdesk? And well, today I'm going to give you a few words about it, but before that, I'm going to explain you why intellectual property. Because the India IP SME Helpdesk is all about intellectual property, but sometimes we've seen that that companies don't really give the necessary attention or importance to intellectual property. Meanwhile, this can really become one of your key business assets, and there are a number of reasons for that. First of all, registering your brand, registering your patents, and so on gives you an advantage, and especially in a market like India, where let's say the market is increasingly attractive for companies all around the world, for investors and so on, but it's also increasingly busy, which means that there are a lot of competitors, and having your intellectual property protected gives you a competitive advantage over them. And at the same time, of course, if you have your coherent and complete intellectual property portfolio, gives you exclusive rights over your products and services, you would be free. You have the freedom to operate in the market, and at the same time, you will attract investors, because investors are usually attracted by the fact that if they see that you have your exclusive rights, your package of exclusive rights, it gives them a perception that your company is more stable and more likely to grow in the near future and in the long term. So this is very attractive for them. And at the same time, of course, they are attracted by the fact that you have your own rights, that you have your, let's say, exclusive rights over the products and services that you are offering. So this is very good, especially for small companies, small and medium-sized enterprises in general that are looking for investors, investment, and so on, or like financial resources, etc. At the same time, having your intellectual property protected gives you more control over your products and services, and especially whenever you are outsourcing to India, it will decrease the risk of, for example, counterfeiting. This is extremely important because India, we have to remember that India is indeed one of the top countries for counterfeiting, but it is indeed possible to protect yourself and to actually enforce your rights in India. So, on the basis of this, the India IP SME Helpdesk was established by the European Commission, and the Commission wants that SMEs are supported with free of charge first-line confidential assistance and guidance on IP protection, management, and enforcement, and this is the main objective of the Helpdesk. What we do is to help companies like yours, perhaps, that are established in the EU or in associated countries. This means also Turkey, and you're interested in doing business with India or in India, or perhaps you are a European company that is already in India and would like to have support on intellectual property protection, management, and enforcement. And this is what we do, pretty much. But how do we do this? Well, we have different services that are available for companies and for BSOs as well. The first service that we have is what you see on the screen, the Helpline. Helpline is some kind of system which allows you to get in touch with our IP experts. Our IP experts are available every day for you, you can get free of charge support from them. They can answer any questions you may have, any questions you may have specifically on your business case, on your products and services. And this answer you get in 3 working days, and you can do this by email, phone, and via our website. And it's available in English, Spanish, and French. The good thing is that everything you say to the expert stays between you and the expert. It's totally confidential, and we use a very simple language because intellectual property is not very easy to understand. We try to make sure that you have, let's say, a simplified version of what we are going to say. At the same time, we have also launched a spin-off service, which is the request a meeting with our IP experts. So far, we only had the opportunity for you to get in touch by email, phone, and via the contact form on our website. But now you can also book your meeting, personal meeting, with our IP experts. And of course, all of this is for free. Another service that we have is training. As you know, you are here for this. You are here for a training on IP in the cosmetics industry. And this is what we do. We educate company, we help them to build capacity to make sure that they are able to protect, manage, and eventually enforce their IP rights in India. So this is what we do, and this is not the only event that we actually carry out. I invite everyone to check our events calendar on our website because there are many opportunities that we are publishing constantly every month. At the same time, on the website, you will find online resources. These online resources are kind of like ad hoc made for you. So they are infographics, brochures, and any other documentation that may help you to succeed in India. And finally, we have 2 tools, which you will find on our website, the IP Diagnostic Tool and the IP Cost Tool. For the IP Diagnostic Tool, it helps you to measure your level, your status in terms of IP management and knowledge. So it helps you understand if you have a clear vision on IP in India. And the Cost Tool helps you to make a pre-estimation of the costs that you will have to bear in terms of IP management in India. So it's very useful, especially if you're in that phase of your company where you are trying to understand whether or not India is the country for you. This gives you a good view on how much you will have to take into consideration in terms of costs. And this is pretty much it. So this is what we do at the India IP SME Helpdesk. We stay available for you for any questions you may have. If you have a question about the service, about IP, especially about IP, we are totally available for you. You can check our website. You can connect with us on Twitter, on LinkedIn, and so on. So please feel free to reach us at any time. And this is pretty much it from my side. And thank you very much for your attention. I'm giving the word back to Ségolène.
Thank you, Stefano. It's very important for us to be in collaboration with your institution, if I can say, with this IP Helpdesk, since the idea is that we don't have this expertise within our cluster, and it's very important to make the link with specific expertise, and you are the one on IP, so thank you very much. And just for your information, today we are talking about India, but we also have a collaboration with your colleagues in charge of Mexico, well, Latin America in general, and we'll have also a specific webinar on that more in 2022, normally in April, but we'll let you know about that. But yeah, it's very important, this collaboration to go on. Well, now our expert on IP will discuss about that topic. We'll show you and explain you all about that. As you were saying, Stefano, it's not an easy topic. It's not always fun for people, but I'm sure Girish will be the one that will be able to make it very important for us and very clear for all of you. So thank you, Girish.
Thank you, Ségolène, and thank you, Stefano. Good morning, everyone, and it's glad to be here. And before we venture into this IP expedition on India, I would ask all of you to take this brief kind of a pre-assessment. What we intend to do is to you kindly go on to this website called menti.com and enter this particular code. You have even in the chat, I've just put this website. Once you go there, you have some 5 very basic questions of IP, something related to India, something very generic to IP. This will give us an insight onto what is your present knowledge about IP, and it will also make us, it is kind of a data for us. So we conduct this pre-training and post-training. We'll have to do this twice. So I request all of you to do this. We can have some 3 minutes for this. So Stefano, if you can share.
And yes, I'm already sharing.
Everyone can access.
Yes, I'm already sharing the screen for the instructions. So I'm waiting for everybody to get inside the Mentimeter. You can do this by phone, scanning the QR code. You can do this on your browser. Just type in menti.com, insert the code, or you have, as Girish said, the direct link in the chat. So I'm just going to go now to the next. We already see some likes on the screen. So we're going to go ahead now with the first question, and we see if everything works fine. So very easy question. How many coffees have you had so far? Let's see.
Can all of you answer? You can write in the chat. 2.
So we're getting some results.
Move to the next question.
Shall we move to the next question? Yeah.
Yes, please do move to the next question.
Okay.
And this is something more specific to IP.
So, first question is, conducting an IP audit is not recommended for SMEs and startups given the costs involved. You just have to choose either you think this is true or false.
What do you think about this? That IP audit is necessary, not necessary for a SME or a startup? Great. Can we move to the next question then?
I would say, okay. Next question is, trademarks and copyrights granted in the EU are automatically granted protection in India. Is it true or false? Okay.
Thank you. Yes.
Next question. It is possible to apply for patent protection simultaneously in different countries with a single international application. True or false? Okay.
Thank you. Yes.
Industrial patents and design patents can mutually coexist on the same product. Is it true or false?
True.
All right.
Thank you. Yes. The last question.
Patent and trademark searches are essential before internationalizing. True or false?
Fine. I think so. This was the last question, right?
Thank you very much.
Thank you. Thank you all. Now we can, I just go to share my screen and my presentation. Hello. Can everyone see my presentation?
Yeah, we can see.
Yes. Thank you. So from what I gather from this pre-assessment, the people who answered, they seem to know the basics of IP and how the intellectual property system works. Before we venture further into this topic of IP and IP in India, I'll just draw a kind of a historic vision of how IP developed intellectual property in the 19th century was primarily seen as an exclusivist tool. So it was a tool to block your competitors. But IP also enabled creation of new markets. And this, you can call it as markets for technology. So there was division of labor, there was manufacturing, and then there was a technological market in the mid 20th century and stuff. And as we come further, uh, I think so Dolby was one of the pioneers of completely basing their business model on licensing IP. And then this model has been followed by Qualcomm, and in telecommunication industries, you see a lot of this technological companies whose main business model is licensing intellectual property. So from being an exclusivist tool, we have come to this to view IP as a signaling tool. It basically acts as a signal to attract investment, and it also acts to attract consumers. It gives a sense of reliability if you have a patented product or if you have a certified product, be it from a particular geographical uh, place in with respect to cosmetic industries or anything. It builds trust with people. It also gives you an exclusive right to manufacture, sell, distribute your product. And it is also very important to develop key partnerships in the countries that you want to venture into. Further, it also acts as defensive uh, tool to protect yourself from others infringing, and also you can cross-license IP to use to collaborate and use others' product within your business scheme. So with this open innovation model that we see in the 21st century, IP provides this holistic tool rather than just a limited exclusivist tool which it was seen in the 19th century. Coming to the market of India, I think so even Segolene mentioned this, but it is expected that Indian cosmetic industry is supposed to reach around 30 billion in the year 2026. This is going to be the third largest market after US, China, and US and China. So there is a huge market potential available. And India also provides, as even Segolene mentioned, that it provides huge raw materials, be it through labor or through very organic. Right now, you have this, what do you say, a craze for organic products, Ayurveda, and organic cosmetic products. India also provides a huge opportunity for this. So you can explore this. Coming specific to IP, the plan of the session would be to generally walk you through to the basics of the steps that you have to take, not specific to India, but to any country that you want to internationalize. So over here, you see step 1, which is knowing your IP. Step 2 is to strategize. And step 3, to conduct international searches. These are generic aspects before you internationalize. Further, in the step 4, we go on to Indian specific laws and particularities. You will see further how we go through. The first thing that I would advise all SMEs and startups to do is to conduct an IP audit. And what does an IP audit mean? IP audit basically means creating a IP inventory where you kind of tabulate all the IP assets which are there in your company. And as you see over here, IP is there everywhere. Even a single product which you have will have multiple IP protections on it. There'll be trademarks. You can protect the brand through trademarks. You can protect the shape, the aesthetics through designs, copyrights, and also if there are some secret formulas or if you are using any machinery, if you are using software, all these things can be protected through trade secrets. So there are various IP tools available to protect one single product. So within your company, you might have one single product, but you can avail many IP protections, and all of this is valuable information. So the first step would be to conduct an IP audit, where you create a list of saying what all IP assets that your company holds, what all IP assets that you have acquired, or even potential IP assets that you might acquire, and the IP assets or the information that you have outsourced to others. Knowing what kind of IP, knowing where have you protected, has the information or the intellectual asset, does it have protection? Have you registered it? Have you paid the fees? Have you licensed in, licensed out? This would be the basic initial step to conduct to kind of build an IP inventory, which every SME and startup should do. Once you have created this IP inventory, then you can strategize on the needs, on your specific needs. What do I mean by strategize? It's basically assessing the costs involved and the means of protection that you want to avail. So as you see over here, there are two images, one on the right, on the extreme right, the white and blue image. I think so everyone can directly see this, and probably this is Head and Shoulders, the shampoo, and there is another bottle. So the same product can have a design protection and it can have a trademark protection. Over here, we see that the Head and Shoulders white and blue color with the specific shape has gained prominence in the minds of consumers, and this has been protected in India under trademarks. And whereas this other bottle, the green one, has been protected under designs. So it is for you to choose which path to take, which protection to avail. You can't invest in everything, and based on your strategic needs, you will have to see which is the best thing to do. I can give you an example. There was this one example of a bed light manufacturer who was in a dilemma whether they had the specific design with specific color for the bed light and stuff, but they were kind of unsure whether to protect it through designs or through trademarks. It was initially advised that it is better to protect it as a design, which gives you 10 to 15 years of protection. But post 15 years, once your design protection ends, if your specific design of the bed lamp had attained a sense of, with consumers, if it was famous and it has attained this kind of everyone knows about it, then you can apply for a trademark for it. So you can strategize which is the best means of protection for your product initially, and then further on, you can, if it gains in prominence in the consumer eye, then you can go on to protect it as a trademark. Further, you have to strategize about your markets that you're going to venture into, the competitors in the market, the potential investors. Most of the times we see that SMEs and startups, they directly try to internationalize. They directly try to get into some distributive agreements with the local players, be it someone from India. They get into some agreements and there is no delineation between the ownership of the IP. So these things can create a lot of issues later on. So having an IP strategy is very essential. So the first step is to conduct an IP audit, and then next, have a IP strategy specific to your needs. Once you have these two in place, then we suggest that you conduct some intellectual property searches. Why would you do this? The first and primary reason is to see whether the product or the brand that you're entering, say, suppose you're entering India, you conduct an IP search, Indian specific search on patents and trademarks to see whether your product or your brand has already been registered by some of the regulatory authorities. someone else. So to avoid infringing, you need to conduct an IP claim. Once you've conducted, you claim an exclusive right. Further, it also provides you certain strategies and insights about the local market, about the collaborators and competitors in that particular market. It gives you an insight into this. And this is not very difficult to do, though I would advise before registering that you consult an IP boutique or perfect trademark searches and patent searches for this. But we advise you to do it yourself, in the sense there are this free open source databases available. For patent search, you can go to PatentScope, which is a database by World Intellectual Property Organization, and it has Boolean fields. So you type in the kind of product that you have, or the IPC class, the class of product or the process that you want to patent, and it lists you all the available patents in that particular category of products or processes in India. And it will also give you the applicants' names and stuff. So then you get a general feel of who are the players in that particular arena. The same thing, there is, you can also conduct it on the Indian intellectual property patent search website, which is not that user-friendly, but I would suggest the WIPO, which is World Intellectual Property Organization situated in Geneva. They have this free database, and this one must be compulsory for anyone before internationalizing. And you can play around. You yourself can play around rather than consulting a lawyer, this tool. Secondly, I would also suggest you conduct a trademark search. Again, you have a free database by WIPO, and then there is an Indian database. You can type in the product name, the goods and services that you are involved in, and then you get a brief idea about all the trademark or the brands available in India for that particular product class. So this is, once again, the first step: audit, then have a strategy, and then conduct this basic search to get to know whether your product or your process has already been protected in India or not before internationalizing. And these are very important because we've seen companies suffer because of this. They directly try to internationalize, and then things get overboard. Once you have done these 3 steps, then we can go into specifics about Indian IP laws. So what is Indian IP? Basically, being party to the TRIPS agreement, protects the most common intellectual property tools, be it patents, industrial designs, trademarks, copyrights. We also have something very specific known as geographical indications. Even in Europe, you have geographical indication protection, but basically for agricultural products. India also offers protection for non-agricultural products. So be it some artisans, handicrafts, or some toys from one specific region, these can be protected under geographical indications. And we also have protection for trade secrets, though India does not have specific trade secret regulation or a law. Indian Contract Act provides you, in consonance with the Indian Penal Code, it provides you mechanisms to protect your trade secrets, be it algorithms, recipes, the customer list, drawings, or whatever, which you feel is important for your business. This can be protected through trade secrets. So now I'll go through this. I have just kind of done a basic life cycle of a cosmetic product. The first thing would be probably getting the raw materials, then you manufacture, then branding, and then you entry, the market entry. So when we think about supply of raw materials and labor, the first thing which comes to mind, for me at least, with the growing need, with the growing consumer demands of organic products, is, and even in India, we have this huge what do you say, demand for organic cosmetics, Ayurveda, and stuff. And this one, there is one specific thing that you have to keep in mind, that India has something known as National Biodiversity Act. So if you are sourcing any organic material, be it in India, we use a lot of, I don't know if you know, tulsi, sandalwood, or any of this material which you source into your product, and you want to protect it in India through a patent, you have to get this permission from the National Biodiversity Board. So this is a compulsory thing that each and every European SME should keep in mind, because we have this one particular case right now where a UK firm is trying to extract from a plant in India to build a medicinal product, though not a cosmetic product. And they haven't got this approval from the Biodiversity Board. Without getting this approval, if you apply for a patent, then the patent will later on can be discarded, can be revoked, and there is also criminal sanction against this. So there is also imprisonment up to 3 years and fines up to 10 lakhs, which is around 1 million rupees. So one should make sure that if you are extracting any material from a biological material from India, you get this requisite permission from the National Biodiversity Board. And then further, you can you also submit this in your patent application. So this is one thing that everyone should be aware of. The second thing is with respect to this material is India also has a lot of, as you see over here, protection for cosmetic and beauty products. You can claim something known as geographical indication. This is another kind of protection if you are sourcing a particular product from a particular region. Say over here we have 3 examples of Himachal chulli oil. This is in the north from the Himalayas. There's a specific oil from apricots, which is supposed to be a beauty enhancing. So this has been given GI protection in India. There is also this Kannauj perfumes. This is again an ancient place where perfumes are distilled and kept in camel skin. So even this has gained geographical protection in India. And there is this very famous another soap which is distilled from the sandalwood. So if an European SME or a European startup or anyone in Europe, if a company wants to protect a specific ingredient from Europe, this can be protected in India. You can claim GI protection for that in India. So this also gives you a trust with consumers. Consumers are really happy when the product is associated. There is this general inclination that be it Mysore sandal or Kannauj perfume, these have millennia. These have over century old. These are century old traditions and stuff, and they have kind of seeped into the minds of Indians. Post this, if you come to the second thing, which is supply and then you manufacture. In the manufacturing, you can have processes of manufacturing, which can be protected through patents, and the product itself can be protected through patents. There are specific things to be aware about India with respect to patents. One is, how do you file for a patent? The easiest way to file for a patent in India would be through the route of PCT, which is Patent Cooperation Treaty. So you file for a patent with World Intellectual Property Organization in Geneva, and this gives you a 30 to 31 month period to enter and file for a patent in India once again. So what happens is there are two phases when you file for a patent through the PCT route. One is known as the international phase, and the second is the national phase. As most of you might know, that intellectual property is a territorial right. So if you have a protection, say in European Union, you do not have a protection in India. You'll have to apply or file for a patent or an trademark or copyright in India to gain protection. So when you file for a PCT through the PCT route, you file for a patent and then you designate or select India as one of the designated countries. So what it does is it gives you a 30 to 31 month period, post which you can, once you have gone through this phase of international search and international examination, you take this reports and then enter the Indian phase after 31 months, and then the Indian Patent Office grants a patent. So usually we have seen that some SMEs would have filed a PCT patent, but they lose this 31-month period. They do not have India in their strategic interest, and then there was this one recent SME with which this happened. They had got a patent in around 2017, 2018, but yeah, they had the 30-month period had been exhausted, so they couldn't file a patent in India. So, but the PCT route gives you this time period of 30 months to file for a patent in India, and the priority date would be the date of filing through the PCT application. The other thing with respect to patents in India is that you furnish details of your patent applications in other countries. Say, for example, you have filed for a patent for the same patent in Europe with the EPO, and you have filed the same patent in US, and you file the same patent in India. The Indian Patent Office requests or mandates that you provide all the examination reports of the EPO and the USPTO to the Indian Patent Office. Not doing this can later can be the reason for opposition or even revocation of the patents. So you have to make sure that any details about you filing in other countries that particular information is given to the Indian Patent Office. Another specific thing with respect to patents in India is known as statement of working. So this is very specific to India. So what happens is, once you're granted a patent in India, if you have not worked the patent within 3 years, this can be a ground for revocation. So what does working mean? So once you have been granted a patent in India for a product or a process, you have to file, which is now the infamous Form 27. So you file this form stating that your patent has been used in India, the product is available in the market, or you have licensed the product to someone who has made it available in the market. The main reason for this is the Indian Patent Office wants to make sure that the patents that they grant are used in the market of India. So all European enterprises should make sure to file this statement of working post 3 years of grant of patent. Further, if you have any software involved in manufacturing your cosmetic products or anything, these can be protected through patents if they have an industrial application. Otherwise, you can also protect the software through copyrights. Coming to designs, as you know, as you see over here, designs protect the outer shape, the color of the product and stuff. There is a difference between design and trademarks, as I had mentioned earlier. For designs, you do not have this international filing route. You have to file it in the Indian Patents and Designs Office. There is no, so you'll have to consult an agent in India and then particularly file for a design in India, and registration of a design is mandated in India. For copyrights, you do not per se have to register your copyrights, but registration is advisable. Barring this, we'll just go to trademarks now. This is more important with respect to branding. So what happens with trademarks is, if you have a trademark in Europe, you can directly file for the same trademark or brand with World Intellectual Property Office, and then again designate India as one of the designated countries. So this is pretty simple. Everything is online, very efficient. So you can avail this. The local lawyer over here in Europe can uh, apply for a trademark through this route in India. India provides you uh, protection for 3D, three-dimensional marks, be it packages and stuff, the way you package. But you have to choose which protection would you need. If your product, say over here, as you see the shampoo bottle over here, can be protected, or it has gained influence in the minds of people in India, then you can claim for a trademark protection. But sustaining this three-dimensional marks is tough to argue that you need protection initially itself. If you go with this bottle and if you seek protection, then this can be tough to argue in the with the Indian Trademark Office. So the first advice would be to protect it through designs. Then later on, once you build your brand slowly, say in 5 years, 7 years, then if your product has gained influence in the minds of people, then you trademark protect it, because the design protection is only for 15 years. Post that, trademark protection is you continue renewing it. So trademark protection offers you a longer duration of protection, but you have to make sure how you strategize. India also offers trade secrets. So this is one other thing that you have to make sure when you get into any supply contracts, or you are extracting information from, you are kind of collaborating with a person in India, you're extracting a biological material from India, that you sign non-disclosure agreements. And non-disclosure agreements is the first step. Then when you get into specific contracts, make sure who has ownership on what. If the technology is from Europe, you have to discuss and say that, okay, the ownership of the technology or the patent would be with you. And if the material is being supplied from India, they get certain rights. So everything, having clear specific clauses in distribution contracts, technology contracts, or non-disclosure agreements is very, very essential. Make sure that you have this, be it supply contracts, or if you want to protect your client list or customer list, anything can be protected through this, but make sure that you have this agreements and specific clauses with respect to damages, and during specific clauses with respect to during the time of collaboration and post the time of collaboration. What I specifically mean is, when you get into a contract with a person, you have specific clauses on the use of trademark and patents. Post that, what happens? You should have specific clauses with respect to that, because usually we've seen that there is counterfeiting and infringement happening in India, and Indian companies tend to overdo things, and they use the brand which they would have licensed earlier and continue to use that, though the contract has ended. So make sure have specific clauses with respect to this. Branding and the e-commerce market is pretty huge. There are a lot of avenues available. Amazon and Flipkart are the main brands. If you have any if you have any of your products or intellectual property being infringed, you can, there is something known as Amazon One, which Amazon has right now created. And then even with Flipkart, with specifics of your trademark registration, copyright registration number, if you supply to them, they take down the product. The problem is not with these main players. The problem arises when you have these other websites which basically propagate or they advertise counterfeit products. Be it, there is this website called Clone Cart, Designer Bags. So these things over here, there are also cosmetic products available. So what do you do when now you come across these websites? The first thing would be to identify the counterfeit product. You determine the areas or the deals with the counterfeit product, determine the businesses, where the business is located, how are they selling it. Further, you'll also, over here, you need to get specific info about where is the server hosted, how are they carrying it out, what are the payment gateways available. If you have all these details, once you have conducted this investigation and you have these details, there are law firms available doing this in India, then enforcement becomes very easy. Any infringement or counterfeit products is a cognizable offense under trademarks law, copyright law, GIs, and even design law. So if you come across such websites or such individuals conducting this, and you have gathered sufficient information about this, you can directly go to the cops. Being a cognizable offense, even without a warrant, they can raid, and there is something on a search and desist order, so they can do that even without a court warrant. So having specifics about who are the individuals individuals involved in this infringement and the location of infringement is very important. And having the specifics and having registered trademarks and copyrights would help a long way in enabling enforcement. As I had said, India offers both criminal enforcement and civil enforcement. Say, suppose you have, I just explained this, saying that if you have the specifics with respect to any infringement, you can directly report it to the police. You file something known as the first information report, FIR, and then the police can directly raid the premise and seize the goods, and then there would be subsequent a court hearing. You can also go through the civil enforcement route, where you go before the civil court, and then the court itself, upon providing prima facie evidence, on seeing the evidence, the court itself appoints something known as court commissioners, who would be sent to the location to seize any documents or to seize the goods based on the case. So Indian enforcement mechanisms, though the courts are overburdened, the enforcement mechanism works. Though though getting the final order might be delayed, it might take, if you pursue any trademark issue, it might be, you should at least keep 2 years in mind. But the initial cease and desist can happen within 2 to 4 weeks. So you should be happy with that, though the length of the court procedures can be extended, and the total case might take around 2 to 4, between 1 to 2 years. There are also custom measures available. One, if you have registered your rights, you give your registered trademarks and copyrights, your registered trademarks, you mention it to the customs authority, and they have a database on this. So if you find any infringing product imported to India, you can tell the custom authorities, and they seize the good over there. Having registered rights is very important to enable any of these measures, to avail these measures. Finally, India is also offering series of benefits for startups and SMEs. There is expedited patent examination available, and there is also considerable fee reduction for SMEs and startups. So even European SMEs can avail this. So I would request everyone to check this and use this option. To finally conclude, some of the FAQs, some of the frequently asked questions to me about India is, you have a patent or a trademark in Europe, can it be protected in India? Yes, it can be. We would usually advise them to go through the PCT route, which is the WIPO, World Intellectual Property Organization. You file it over there and just designate India as one of the countries. The other right now we see a lot of AI being used in all the manufacturing processes. So if you have any software or anything that you use within your company, the best possible means would be to protect it through, I would say, if it's an algorithms per se cannot be protected through patents. It should have an effect, a technical effect. So if it does not have that technical effect and you don't use per se some sensors, hardwares and stuff, then I would suggest you protect it through trade secrets, through NDAs. Approximate costs of patenting in India would be around, we can say it's around 2,000 euros. If you have already done your filing in Europe, you have the claims written and everything, and just the filing fees and the agent fees, everything would cost around 2,000 euros. And for trademarks, it would be somewhere around 600 to 700 euros. And the enforcement mechanisms do work fine, but you got to be patient. If you come across any infringement, collect basic evidence that you have your registered rights, go to the police, and there can be search raids conducted with the police then and there. So within 2 to 4 weeks, you can have some relief, but the court procedure can last for up to 2 years. So finally, we end. Again, I stress on this 3 parts, 3 things, basically, which are generic to if you want to internationalize to any country, which is first, know your IP, perform the IP audit, assess your risks, strategize, conduct prior art searches, which is very helpful, and you can conduct it yourself rather than outsourcing it to someone. You can play around this websites, and there are Boolean operators, so you get a view of the market in India and the collaborators. And finally, you can learn about the specific legal jurisdictions and the local needs, local laws about India. With local laws, because you are involved in cosmetic industries, and if you source any organic product, I would just request you get this approval from National Biodiversity Board, which should be the first step. If you want to protect your brand, it would be through trademarks. India offers design trademark, 3D trademarks, and also you can avail design protection. Initially, we suggest that if you are venturing into India, protect your packages through designs, and then later on, you can trademark them when they gain influence, depending on your business needs. With this, I think so. Oh, finally, I'll just talk about these tools. If you have any doubts, you can contact us anytime. But we also have this diagnostic tools where there are this set of questions that you answer, and you get a report with correct answers and insights into the Indian IP laws. And also you have a cost tool where you get insights about the cost involved in patenting and trademarking in India. If you have any specific questions, I do understand, but that this was probably pretty generic. I was intending to give kind of a IP landscape of India. So with the limited time we have, if you have any specific questions, you can ask me, and then you can also request for a one-on-one meeting on our website. And I usually find that having one-on-one meetings helps a lot for enterprises because they can formulate their thoughts better, and we can probably discuss a lot more during those meetings. So thank you.
Thank you very much. It was very, very interesting. You were saying it just an overview, but you went deeply in each part in any case, so it was interesting. Of course, any companies, depending on their skills and their job or the product they are selling, the question might be different. But as you were saying, and as Stefano said, it's very important to have in mind that the help desk is made for that, and don't hesitate just to contact them contact them directly and to ask your specific questions. So this is very, very important to have that in mind. Don't hesitate. You won't bother them. It's their skills and they are here for that. So it's very important.
If
To finish,
sorry.
Yeah,
Yeah,
go
I
ahead.
would just once again, I would just request everyone, all the participants, if this session was helpful, I would just request you to again enter this menti.com and just answer this post-assessment question. So this gives us an insight whether the training was helpful and stuff. This is a metric for us. I would just request them to do that. And Stefano is already sharing the
Yes.
screen.
Yes, I'm going to share also the link in the chat for those who cannot join from the phone, for instance. You have the direct link in the chat. I invite everyone to join the Mentimeter. It will be very quick, like we did it at the beginning. So let's do this. The questions will be actually almost the same because we want to see how much this has changed from the beginning until now. So let's do this. Let's go to the first question, which is always the easy one. So how do you feel after this training? Good. Do we have more answers?
People feel
They're tired, I bet.
they're tired and they need coffee. I hope.
All right, let's go ahead. So, as always, conducting an IP audit is not recommended for SMEs and startups given the costs involved. Is this true or false? False. Trademarks and copyrights granted in the EU are automatically granted protection in India. We get no answer anymore.
This is tough.
Okay. Great. It is possible to apply for patent protection simultaneously in different countries with a single international application. True or false? True. True. Okay. We got 2 answers. 3 answers for true. Okay. Cool. Industrial patents and design patents can mutually coexist on the same product. What do you think? True or false? Okay. 3 answers for true. I think we are almost at the end. Patent and trademark searches are essential before internationalizing. True or false? True. True. Yeah, indeed. That's it. Thank you very much. And I guess, Girish, we have the feedback poll, right?
Yes, we have in the post, we just have a question, the feedback, and then there will be feedback sent to their email.
Yeah, and I would like just to share a little document just to have in mind the next step for the acceleration program while you're answering also the poll. Just a few.
Yes, so the poll is available on the bottom of your screen, bottom right. There is a small button which is called polls. So I invite all participants right now to just, it's very quick. It's just an answer, you just click and submit.
If you have, I would request all participants, if you want any specific trainings with specific aspects about internationalizing to India, we would be available to conduct that.
Yeah. So I just put in that slide a few key points about the acceleration program on the specific target market we are focusing. So I kept the same slide as the beginning, but just with key links. You have access to all the bulletins, market bulletins, and focus country market studies online on the website. So don't hesitate, as a member of the different clusters involved in that project, to ask for those studies. They are free to access. You just have to register. We'll have, as I said, some more webinars in the following month in order to focus on those markets. So the restitution of the cosmetic market studies on USA and India and South Korea. And we'll also have in April, so the same type of webinars as today, dedicated to Mexico, thanks to the IP Helpdesk on Latin America. And don't hesitate also to ask for specific advice, data on IP, so directly with the helpdesk, or on the cosmetic industry, more to us as clusters involved. Don't hesitate, we are here for that also. And just key dates for the international trade and partnership opportunities. We are finalizing the B2B Business Place platform. It should be online, ready for everyone on January. And the two missions we were talking about earlier to South Korea and USA as European collective mission, but dedicated to each company's needs. So don't hesitate to ask for any question, whether to gcc.eu partners, whether to the IP Helpdesk that made a great job today to explain us about that topic, which is not always easy to understand, but was very clear thanks to your presentation, Girish.
Thank you. Hopefully I was clear.
Okay.
Thank you, Ségolène.
Thank you, everyone.
Thank you.
Have a great day.
Have a great day. Bye-bye.